All rise. The Court of Appeals Division 1 is now in session.
Thank you. Please be seated. Good morning.
Good morning.
We are here for oral arguments in case number CV20-0382, electronic payment v. Kennedy et al. A couple of housekeeping items before we get started here. And Mr. Woodard, did you bring your bodyguards with you today? Is that what I understand?
Actually, Your Honor, I did bring a bodyguard. This is my colleague, Shalane Pillar. I believe Mr. Dowell brought the real bodyguards.
You brought your bodyguards. Well, that's good.
Yes,
Bodyguards are always welcome here at court.
Thank you.
Just so you know for future reference. A couple of housekeeping items before we get started. In more normal times, we would invite you to stand here at the podium during argument, but because these are not those times, we invite you to just stay seated at council table throughout the proceedings. As you can see, our panel is physically distanced, and we have removed our masks to make it easier to communicate with you. If you would like, you're welcome to remove your mask during argument. Of course, you're also welcome to keep them on if you're more comfortable. These proceedings are being video and audio recorded and live streamed, so we ask counsel to please identify yourself and your client at the beginning of your argument. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal if desired. Also, please keep in mind that we've read the briefs and have conferenced the case this morning. And with that, counsel, you may proceed.
Thank you, Your Honor, and good morning. Appreciate having the opportunity to communicate with you about appellant's and plaintiff's position. My name is Josh Woodard, and I represent electronic payment providers doing business as Billingtree. And with me this morning is Shalane Pillar, my associate at Snell & Wilmer, also representing the appellant. So I'd like to highlight just a couple areas, Your Honors, about why we believe the trial court erred in granting summary judgment for the defendants. First, we believe that the trial court erred when it found that the restrictive covenant at issue was unenforceable as a matter of law because blue penciling was required. There's really four concerns with that position that the trial court took. First, the Supreme Court of Arizona has acknowledged and allows the severing or blue penciling of agreements. In 1986, in the Oliver Pilcher case, the court says, if it is clear from the terms that a contract was intended to be severable, the court can enforce the lawful parts and ignore the unlawful parts.
Does that give the court discretion then to blue pencil?
We believe the court does have some discretion as to the blue penciling, and that is clear at the trial court level. However, I think that then the court is obligated to look at the intent of the parties. I think the court is obligated to exercise its discretion as opposed to just failing to exercise any discretion whatsoever. And so we believe that, we believe that the trial court needs to look to the intent of the parties. And here in the contract, there is a severability clause and a step down provision with respect to the geographic scope. And so by the court not...
Counsel, let me interrupt you there. Even if they step it down or sever out, what is the narrowest geographic scope that the contract could provide for?
Here, the narrow scope of the geographic provision would be the United States.
Okay. Can you point us to any case in which an Arizona court has upheld that a nationwide non-competition covenant with that geographic scope has been upheld?
Not in the context of an employment relationship as opposed to a sale relationship, which we're not talking about here, but in context of the employment relationship, no, I'm unaware of any court that has found a nationwide scope to be reasonable. However, courts have recognized that if an employer has a protectable interest, namely confidential information, client goodwill, customer goodwill, that is subject to restrictive covenants.
I view those more as dealing with the non-solicitation portion. And I realize that that's not necessarily a bright line rule, and you're free to argue that, but without tipping my hand too much, I don't see us enforcing a nationwide covenant in this situation. So maybe you could focus on your non-solicitation provision.
Sure. If I could just address, Your Honor, that the one comment that you did make. I think if an employer establishes a nationwide scope for their business and it needs to protect that business via restrictive covenant, confidential information, and a non-solicit, and it's not just preventing competition per se. If the employer has a legitimate business interest to protect, I believe a nationwide scope is appropriate for a non-compete. So despite the fact that no court that I'm aware of that has held that particular provision to be upheld, I don't think it's a per se bright line rule that it's automatically unenforceable. I think it would have to go to an evidentiary hearing to allow the parties to explore in front of a finder of fact of whether that nationwide scope is or is not appropriate. And what's interesting here, Your Honors, the court did not make any factual findings as to whether the United States was a reasonable scope or an unreasonable scope. And because of that, we don't believe that defendants have met their burden to show that there's no genuine issue of material fact. So because the court made absolutely no findings. And again, back to the first of the issues I wanted to address is the very fact that the court said, look, the judge would have to blue pencil out Europe and Canada, that automatically made the provision unreasonable. And we don't think that's what the parties contemplated. When you look at the agreement, there is a severability clause and the step down clause. And what you're going to hear from defendants.
Wouldn't your logic, though, especially regarding in the internet era and everything being interrelated, which you make a great argument of that in your briefs, then a worldwide limitation would be per se reasonable, or could be found to be reasonable. Haven't we just written out the idea of a limited geographic scope completely, which our Supreme Court has told us over and over again that we have to apply?
I don't think it's written out completely, Your Honor. I think in the right circumstances, could you have a worldwide non-compete? I suppose I could come up with one, someone like a Apple or a Google or one of those types of companies, but that's not what we're talking about here.
Aren't you?
What's that?
Aren't you? I mean, that's what you tried to write. Europe, Canada, the United States. There's not a lot left in the English-speaking world, at least.
Well, it was drafted broadly, and we acknowledge that. However, Billingtree never sought to enforce Europe or Canada, nor is there any evidence that defendants sought to seek employment in Europe or Canada. So I think that becomes an issue that's no longer at play here. What Billingtree did was attempt to enforce its legitimate business interest and protect those in the United States. And I do think this is a circumstance where a nationwide scope would be appropriate given Billingtree's reach here. What you're going to hear from defendants and what you saw in their brief is they believe that Billingtree was asking the trial court to save the agreement by blue penciling. However, when you look at the severability clause and the step down provision, Billingtree is not asking the trial court to save the agreement. Billingtree is asking the court to enforce the agreement.
And finally, I'm going to ask you my question.
Oh, yes.
Okay, to what extent should the court be allowed to blue pencil? You talk about we can cross this out and we can do this, and if it changes, how much of your provision is it beyond blue penciling? How are we supposed to determine what is beyond the scope of the court's discretion? I'm having a little bit of trouble with that, especially when it comes not to the restricted territory, but to the non-competition portion of this contract. So how could the court have saved that? I know you say in your briefs you can cross out this and comma this, but I don't think it goes to the intent of what you were trying to achieve by the contract language itself.
And Your Honor, are you talking, I know you're not talking about the United States versus Canada versus Europe. I think you're talking about the scope of the restricted conduct, or are you talking about the non-solicitation?
Non-solicitation.
Okay, thank you. So on the non-solicitation, we believe the court erred there as well by, at the very least, not allowing this to go to a finder of fact to determine what the intent of the parties was. There is a provision in the contract that talks about how the parties jointly drafted this agreement. So there was some argument at the trial court level, and I even think on the briefing at this court's level about how it should be construed against Billingtree, and that's just not accurate. It is jointly drafted here. So I think you have to go look at what the intent is. I know the trial court ruled that because of the comma in the non-solicit and the subset, that as a matter of law, that second clause was superfluous. When you look at the court's ruling, however, and this is at Appendix 200, when you look at the court's ruling, the court really read in a word into that second clause, which really said, hey, what Billingtree's trying to enforce here and to restrict is a solicitation of all customers and clients and a solicitation of all customers. So the court read in a word to that second clause that made the second clause superfluous. We think that's an inaccurate reading, obviously, as set forth in our brief. But at the very least, we think it ought to go to an evidentiary hearing so we can look at what the intent of the parties was with that. We don't think defendants met their burden. That as a matter of law, that's how that non-solicitation clause should be interpreted and read. I think it's unclear. And yes, it is unclear. And yes, we believe, given the blue penciling that we suggest on page 26 of our brief, that it can be saved. But I want to answer the court's question about how do you draw that line? I think if the contract did not contemplate severability, then I think that interim effect comes into play more. However, when you look at the contract, what did defendants get in exchange, or what did defendants get? Defendants got employment, training in the industry, introduction to nationwide clients and customers, and salary and benefits. And one of the defendants received up to $600,000 in salary. So in exchange for that, so Billingtree says, hey, defendants, here you go. Here's a package of compensation and benefits for you. In exchange for that, defendants said, we agree that we will not do XYZ in this certain territory. And they agreed to a severability clause and a step-down clause. If defendants who jointly drafted this agreement didn't want that, they could have negotiated that out. They could have not entered into the agreement. So what defendants, when we hear from defendants that Billingtree wants the trial court to save this, that is not the case. Billingtree wants the trial court to enforce the terms that were agreed to, which is severability. And so once you have that, I think
we agree with you, counsel, that we agree with you that severability is something that courts are allowed to do, and or blue penciling based upon a severability clause is something that courts are allowed to do. How would you sever your non-solicitation clause and still end up with something enforceable? And I'll tell you the problem I'm having as I read your argument that you made below and your argument in your brief. If we do the severing that you want us to, it's still unenforceable because it would be every client or customer of Billingtree, which cases have told us that can only be limited to those customers that the employee had some contact with or had established, used the company's goodwill towards. So how would you sever this?
Thank you. 2 points in that regard. The first point is if the court were to blue pencil, as we suggest in our moving papers, that would put the limitation of interaction with defendants within the 12-month period before they ended their employment with Billingtree.
But it would still be all clients and customers of Billingtree that within the last 12 months, or is it just that they'd had contact with within the last 12 months?
The latter, Your Honor. So it would tie it to the goodwill associated that the defendants had with the customers. So as we propose the blue penciling, that would, it would clarify what we believe the parties' intent were. Again, there was no findings of fact on that issue. The other point is the court did not make a factual finding as to whether a ban on solicitation for all customers was reasonable or not. There is evidence in there that there were customers national in scope, there were cross-territory crossover in terms of confidential information and sales. And so there was no findings of whether a prohibition on the solicitation of all customers was or was not reasonable. I think in the right circumstances, you can have a ban on all customers, but our suggestion on the blue penciling of the non-solicit would put the limitation of the 12 months and contact with the defendants. That's the scope of the customers that we believe the intent of the parties was. But again, there was no finding of that. And I think that
let me go to that just to make sure I understand. So Billingtree's proposed blue penciling is get rid of little I. The actual clients and customers of the company, get rid of comma and get rid of little double I. So it reads the actual clients and customers of the company and those active prospective clients or customers of the company, which the employees alone or in combination with others, ... Doesn't your proposed blue penciling still preclude the defendants from contacting any client or customer of the company?
I don't believe so, Your Honor. I believe that the limitation of the contact with the defendants would apply to both the actual customers of Billingtree who had contact with the defendants and the prospective clients of Billingtree who had contact with the defendants.
So if we don't read it that way, counsel, your blue penciling wouldn't get you out of the preclusions that we've been discussing. Would you agree? If we read it, all customers of the company, and then if you had contact with a prospective customer. So how do we get around that if we're reading it differently than you are?
Well, Your Honor, I think it calls for an evidentiary hearing then to determine whether it's a reasonable enforcement to preclude the defendants from having contact with all customers. Again, there was no finding in that regard. That may be the case. And so even assuming this court does not agree with the blue penciling, and I respect that, we think that it should go to an evidentiary hearing to determine the intent, especially given the issues that we've talked about. But if this court finds that that paragraph reads that the defendants are unable to contact any customer, period, I think it needs to, there's no finding of fact in that regard. So let's have an evidentiary hearing in that to determine whether the defendants had enough of contact with all customers such that that becomes a reasonable restriction on them.
Okay, I think I understand now better your argument. So just want to make sure I'm clear and correct me if I'm wrong. You're saying that the as blue pencil, by deleting the Romanettes and the comma, you're saying the actual clients and customers and the active prospective clients and customers which these guys service.
That's correct.
So it's all of those which these guys service. So you're narrowing it to the ones that were actually serviced by the defendants.
That's exactly
Okay.
Correct, Your Honor. And we believe because there were no findings as to the intent of that, and the court ruled as a matter of law that that was not a proper interpretation, we think that the clause at best was unclear. So let's go to an evidentiary hearing. Let's let the jury and or the judge look the parties in the eyes and see who's telling the truth. And because of that, the defendants, we do not believe, met their burden of proof of showing that there's no genuine issue of material fact. And so
I really want you to get to this point. Let's say we accept what the trial court did. Both clauses are unenforceable. How do we get from there to your breach of good faith and fair dealing claims and tortious interference with business expectations? So those were precluded as well. How do we get there?
So how does those claims survive this?
Correct.
Got it. I wasn't sure if you were asking how did the trial court get there, and I was going to agree with you. I don't know how the trial court got there, but I understand the question. So we get there because the breach of covenant and good faith of fair dealing exists outside the terms of the contract. number one. Number two is even if you strike the restrictive covenant portions of the contract, there's the entire contract doesn't go away. The contract still exists, maybe less those portions that could be struck by this court, but the covenant of good faith and fair dealing survives irrespective of what happens to those restrictive covenants. In addition, according to ORCA, there is a covenant of good faith and fair dealing that exists in just the employment relationship. And so we think that there was almost no discussion whatsoever. The court threw out both of those claims, despite evidence, by the way, of possible breaches of fiduciary duty from a defendants who one of them set up, Lucent Pay, the competitor here, was set up at the time one of the defendants was still employed. One of the defendants used a Lucent Pay email at the time he was employed. One of the defendants solicited a vendor of billing tree for Lucent Pay at the time he was employed. And so there's a number of pieces of evidence that are unreconcilable in terms of getting rid of that claim that exists independent of that contract. And so we believe, irrespective of what this court may do with those limited restrictive covenants, those claims need to go forward because those are subject to genuine issues of material fact. And I believe I'm nearly out of time, and I want to be respectful, and I suppose I'll reserve 25 seconds.
Okay, thank you. You got 30, actually. Go ahead.
Good morning, Your Honors. Billing Tree in this case is trying to do two things that are completely unprecedented and under Arizona law, and frankly, under the law of most states in the United States, and that is to enforce a nationwide restrictive covenant to prevent two former employees from engaging in any competitive business, broadly defined as any business that engages in or uses electronic payment processing in any capacity, not just the sales capacity in which these two gentlemen worked, but in any capacity. And the second thing is they want to enforce a non-solicitation provision that prohibits them from soliciting the business of any client of Billing Tree, not just those clients with whom the defendants had some meaningful sales contact.
Counsel, unlike what
Yeah.
we typically see where you sign an employment contract that's drafted by the employer, they get to determine the terms, it's boilerplate. This says it was jointly drafted by your clients and Billing Tree. How does that affect your argument for the enforceability of those two provisions?
Well, for one thing, it was not. I mean, every contract this is a 22-page contract. It's 22 pages. This was one of 9 contracts Billing Tree had my client sign over the 9 years they were there. This wasn't jointly drafted. Every restrictive covenant agreement I've ever seen, frankly, even those that I've drafted, says it's drafted jointly by the parties. That's boilerplate, and we all know the truth of that. This is a contract of adhesion, to say the least. That wasn't raised in the arguments, I know, but I think the court can look at a 22-page contract and say this
Why
wasn't
does the
drafted.
number of pages matter?
Well, it's oppressive. It's a contract of adhesion. This is not just a simple, you cannot compete and you cannot solicit. This is an agreement that defines every single aspect of their relationship.
What's your authority for saying the number of pages would lead us to conclude that it's oppressive or a contract of adhesion?
Well, Your Honor, there isn't a case law that defines a
Okay,
bright
then I would
line rule
move
that
from that.
says 22 pages or 15 or 50 pages constitutes a contract of adhesion.
Are all non-competition agreements oppressive or adhesive contracts?
Well, as a matter of law, no. Personally, yes, they are. Because the employee has no free right of bargaining position here. They come in and they
A
seek a job.
$600,000 a year employee doesn't have any bargaining position?
No, the one person they're talking about, Defendant Rob Kennedy, who, by the way, I forgot to introduce, that's who I represent, Mr. Kennedy and Mr. Lang. He made that much money in 1 year. That was 1 year. The rest of the years he did not. So that was something that's pointed out. And frankly, it's irrelevant. If we wanted to talk about all the money that Billing Tree makes, which is nearly $60 million a year, and that type of thing, it's really irrelevant to the restrictive covenant part. But the point I want to really emphasize, and I think wasn't really addressed in the briefs of either party, and that is very important here because Mr. Woodard mentioned it probably 7 times. And that is, he said the court should have found as a matter of law, could not have found as a matter of law and made no findings of fact as to the enforceability of these covenants, the reasonableness of these covenants, and that type of thing. He forgets to point out to the court that Billingtree moved for summary judgment. Billingtree cross-moved for summary judgment in this case and said there are no questions of material fact here. The trial court can rule as a matter of law that these restrictive covenants are enforceable. Unlike today, Billingtree never asked for an evidentiary hearing on these issues. Not once did he do that. And now you're saying, well, he should have had a jury decide. They should have had a finder of fact decide. You can't ask an appellate court to do something you never asked a trial court to do. And that's the very same argument with the blue pencil rule. I think the blue pencil rule here doesn't apply at all. I don't think you can ask a trial court or an appellate court to go back and say, well, you know, we think you should parse out this comma and add a comma here and strike sub I and sub 2. When you see what they wrote in their briefs, what they wrote in their briefs is all we did is restrict these former employees from selling to any customer that they serviced within the last year of their employment. See how easy that was to write? You cannot solicit any client with whom you had a material relationship with within the last year of your employment. Billingtree did not do that. Billingtree is asking this court and the trial court to do something it was too lazy to do in the first instance, to draft a restrictive covenant that was reasonable and enforceable, and most importantly, clear. As a state, we want to make sure that if parties to a contract are going to be forced to restrict their subsequent employment, that restricted scope of employment should be clear. It shouldn't require a professor in grammar to decipher what's blue penciled and what's not. And more to the point,
Didn't our Supreme Court in Oliver Pitcher say that if it is clear from the terms that a contract was intended to be severable, a court may blue pencil restrictive covenants to eliminate grammatically severable and reasonable provisions? So I mean, you're saying this is unprecedented, but our Supreme Court has told us that we should do this.
well, the trial court did not say you should eliminate the blue pencil rule. The trial court, in fact, the blue pencil rule is alive in Arizona for sure, but it's a very restricted rule. It doesn't allow the court to rewrite.
Right.
And it certainly doesn't allow the court to go through, I think, and parse through a sentence or a paragraph that's very lengthy, and to parse out commas, eliminate conjunctions and independent clauses, and try to make something enforceable out of it. It's never the court's responsibility to do what the employer is required to do in the first instance, to make a reasonable and enforceable covenant.
So what
And-
is the court allowed to do under this rule?
Well, a good example of that, Your Honor, would be if the restriction said you cannot work in the United States, the state of Arizona, or Maricopa County. And the trial court could say, well, that's just too broad. I think Maricopa County is the more reasonable restriction. So the trial court could strike United States and Maricopa County and do that. But here, Billingtree is really asking the court to do so much more than that. They're asking the court to, again, take out commas, take out parentheticals, take out sub I and sub 2, and write the agreement in a way that's clear and unequivocal, which they did not do in the first instance, and which in their briefs they admit they could have done by simply saying you can't sell to anybody you had a meaningful relationship with in the last year of your employment.
So under your hypothetical with United States, Arizona, Maricopa County, that's what we have here, only it's Europe, Canada, well, similar, Europe, Canada, United States. So
Yes.
could the court have blue penciled Europe and Canada and just focused on the United States then?
I think the court did. In fact, the trial court, Judge Martin said, you've got a worldwide non-compete, and I'm only looking at the United States, the least restrictive part of your geographic area, and the United States is overbroad. These fellows did not even work more than 9 to 13 states. Billingtree admits that. They only worked in 9 to 13 states. They had other sales reps cover the other part. And Billingtree says, well, the mere fact that they could have serviced a client in another territory. That mere possibility that they could have done that means that we're entitled to a nationwide restrictive covenant. Billingtree bears that burden of proof. Billingtree has the burden of proof to demonstrate that that would be reasonable. Is there any evidence in this record, any at all, to demonstrate that Billingtree needs a nationwide non-compete? Their burden? There isn't. And the mere possibility that an employee might enter into a cross-territory sales agreement to sell to a client in another state that they didn't typically service doesn't make a nationwide restriction reasonable. Again, these have to be drafted in the narrowest scope to protect a legitimate competitive business interest.
Counsel, let me shift if
Sure.
I can for just a minute. Let's set aside the non-compete and the non-solicitation for just a moment.
Okay?
Why doesn't the breach of duty of good faith and fair dealing and the tortious interference, why don't those survive summary judgment?
They don't survive summary judgment because, again, Billingtree moved for summary judgment on those counts. Billingtree said there is no factual issue here. We are entitled to summary judgment. And what was the evidence they tendered? You heard Mr. Woodard say. One of the defendants, Mr. Lang, filed LLC papers for Lucent Pay in the last few months of his employment. How does that breach the covenant of good faith and fair dealing? How does that tortiously interfere with any contract? There are cases that are cited in the briefs that show that preparing to compete, including going so far as to forming a business, getting a business name, leasing business space, all of that is in preparation to compete. Even consulting with a lawyer in the one case, the McAllister case and the Motorola case, the employee went to a lawyer, a patent lawyer, established a business, and they said that's all preparing to compete. That doesn't violate the covenant of good faith and fair dealing. But more importantly, if you look at what they pled in their complaint.
He also alleged or mentioned earlier emailing a prospective client.
It wasn't a client, it was a vendor.
I'm sorry.
So in the last 2 weeks of Mr. Kennedy's employment, he sent an email on the Billingtree email account, and he said, hey, would you be interested in entering into a non-disclosure agreement and maybe forming a relationship with us later? That's the extent of it. Their evidence, their burden of proof, their motion for summary judgment, that was it. And nothing happened until over 2 years later when the business, the vendor, GEC, did enter into an agreement with Lucent Pay.
That seems to be, at least facially, to be kind of like the quintessential violation of a good faith and fair dealing. If an employee is actually, while you're employed by your employer, soliciting vendors to work for a competitor, isn't that, why is that? I mean, I'm not saying it's going to win at trial, but that seems to be at least enough to say that there's a legitimate issue there that would preclude summary judgment on that claim.
Well, keep in mind, again, Billingtree asked for summary judgment on that claim. They asked for it, and that's their evidence. They said there's no issue of fact. This is what they did. So we get judgment on that claim as a matter of law. And that's the only evidence they tendered to the trial court. And I don't think there's a trial court in the nation that would say that's enough to carry a burden of proof. That would create a factual issue. That's not what jury trials are made of, those types of issues like that. You've got to have more evidence to show that there's a genuine issue of material fact that really changes the result here.
What's the lacking material fact in that situation?
Well, there's nothing happened. There wasn't a relationship. There is at best one email to one vendor that says, are you interested in partnering with us? That's it. That's what they tendered. That's the entirety of the record. And that doesn't carry the day. That's not what jury trials are made of in this United States. They have to have more than that. And they didn't carry their burden on that. Look at what they've also alleged in their tortious interference claim. They alleged that, well, Billingtree wanted to attend some webinars and not register their own name under it. They wanted to participate in a webinar and say, put down another name here so it doesn't look like it's us. A publicly advertised webinar. Billingtree's admitted in their reply brief, okay, we're backing off that. That doesn't constitute tortious interference with contract. They also mentioned their confidentiality obligations. They said, well, they breached confidentiality until we pointed out in our briefs that Billingtree actually dismissed that claim when it filed its verified second amended complaint. They abandoned that claim. So that's gone. The last thing they have left for tortious interference is they say they have the possibility that Billingtree or that Lucent Pay may have asked someone who was never one of their customers to endorse it and to bash Billingtree. They said it's a mere possibility. The reason why is they have one email that says, would you be willing to do that? That's the extent of their evidence. And again, they move for summary judgment on that point as well. No issue of fact is what they told the trial court. So it's completely disingenuous, frankly, to ask this court to do something it never asked the trial court to do. And they never asked the trial court to blue pencil. What Mr. Woodard said was instructive. He said, no, we asked the trial court to enforce the non-compete and the non-solicitation on its terms. They didn't even ask the court to blue pencil it. They didn't say you should strike the comma, strike the single I, double I. They didn't ask that. They didn't say we need an expert in grammar to come in here and decipher our contract. They never said any of that. They said, it's right there. It's enforceable. And you should enforce it as written. It's very clear to us, Judge. That's all it means. They put all their eggs in that basket and they never asked the court to blue pencil. So how can they ask this court to do something they never asked the trial court to do? It's frankly disingenuous. The employer's burden here is to draft the restrictive covenant so that the employees know when they leave the employee billing tree what their obligations are. We don't want employees to look at their 22-page agreement after the fact and say, well, what can we do? What can we do to practice the profession that we've learned? We would read this contract and say, we can't compete, we can't even work for or consult with a competitive business, any business that engages in electronic payment processing, which, by the way, is not even a defined term. Electronic payment processing means processing credit and debit cards. Every business that I know does that. So they can't compete. They cannot work in any capacity for any business in the entire United States that does that. And I also want to make another point, which I think Arizona law really should recognize here. And that has to do with these step-down provisions. They say, well, we had the worldwide step-down and then that we eliminated Europe and then we had the United States and Canada and then but we only sought to enforce the United States. You can't do that.
How is that different from severability in the first place?
Well, for one thing, does exactly what the courts have said.
It sounds like it's actually doing what you asked, which is to make it very explicit as to what's severable and what isn't. So I was put off by the trial court's reaction to the step-down provision because it seems to me to be indistinguishable from severance.
Well, yeah, the trial court did exactly what Billingtree wanted it to do, and that is apply the least restrictive geographic area of the United States. So I don't even understand their argument about the step-downs being, the court did what Billingtree wanted it to do. And
right,
still said.
You're saying that there's something inherently wrong with step-down, and I'm asking because I don't see what that problem is.
I don't say that they're inherently bad, but what step-down provisions have to do is they have to actually tie something to a reasonable, legitimate interest. You can't just throw in there the entire world less Europe and the United States. There has to be, again, the burden is on the employer to show there's some reasonable, legitimate business interest that's protected by that. And when you have guys that work in 9 to 13 states and you first impose upon them a worldwide restriction, that does have an interim effect on them. When they look at an agreement like this and they decide to try to go out and practice their profession and say, what can we do? And, oh, well, that's a worldwide restriction. We can't, you know how many, I have no evidence of this, of course, but the thought of the courts have recognized how many of these cases actually make it to this stage. How many employees go out there and try to think, well, I want to challenge my non-compete, but it's going to cost me $300,000 to do that, to try to go up against Billingtree and to try to challenge this and say, well, what if the court enforces a worldwide? Then we've lost our money and we're out of business. That's exactly what Billingtree wants. When my kids were young, my kids were young, they're still young. When they were young, I remember the books that we used to have. I'd see them in Barnes & Noble. They were the Find Your Own Adventure books. They were the books that had, like, you could choose a different ending however you wanted it. And that's what Billingtree's trying to do here. They're trying to find their own adventure. They're trying to draft an agreement where after the fact, years later, they can come in and say, well, that's not what we intended. We didn't really mean the entire world. We're being nice guys. We're only enforcing the United States. They're finding their own adventure. And courts, not one Arizona court has recognized the fact that even if you have step-down provisions in an agreement, that you can pick and choose which ones you want to enforce later. Particularly when you as the employer have the burden of proof that there's some reasonable, logical relationship to those step-down provisions to the legitimate business interest, which is their burden of proof. And they haven't done that. They didn't do it at the trial court, and they haven't done it here. And that's why these covenants are overbroad and unenforceable. They are a restriction against competition per se. That's what BillingTree wants. They want someone to look at this agreement, not challenge it. And then when they do challenge it, they want to say, well, we didn't really mean that. We only wanted the United States. Or on the non-solicit, we didn't really mean that you couldn't deal or handle customers within the last year of your employment. We wanted to create this convoluted definition of client. And I think it's game over, frankly. It's game over when you look at the actual non-solicitation provision in this agreement. It says you cannot solicit any client of the business. The term client isn't even defined. They have an elaborate definition section in this contract, and the term client in the actual non-solicit is not defined. They have restricted territory. They have the geographic restricted territory. They have the restricted time period, but the term client is not defined. So you don't even need to get to the definition section and parse through the commas and the sub-I and the sub-2 and that type of thing. You don't need an expert in grammar to get there. You can look at the non-solicitation itself on its face and say client means every client of the company. And we all know that's way overbroad. They can't do that.
Time goes quickly.
Thank you, Your Honor.
Thank you. Go ahead.
Thank you, Your Honors. 3 quick points in my last 30 seconds. This court in
Mr. Dow, I apologize.
That's all right.
Go
I'm
ahead.
sorry.
Go ahead.
Oh, sorry. Josh Woodard on behalf of
Right.
BillingTree, just for the record. This court in Taser found that when there was evidence of a possible breach of fiduciary duty, summary judgment was inappropriate. Mr. Dow failed to mention that one email that we were talking about on BillingTree server was not only on BillingTree server, it came across as a Lucent Pay email account while the defendant was employed by BillingTree. We think that creates an issue of fact. The second point is Mr. Dow, in his briefing, continues to say that this restrictive covenant prevents the use or the defendant's working anybody who uses electronic payment processing. That is not what it says. It has to be design, handle, market, sell, solicit a solution. And then finally, we believe BillingTree has a reasonable interpretation of the non-solicit. If you look at the words handled and serviced, we think that limits the actual customers, and it's a reasonable interpretation. And the court in Thruston said where
10 seconds.
Evidence or inferences would permit a jury to resolve a material issue in favor of either party, summary judgment's inappropriate, and we believe that's the case here.
Counsel, we thank you for your arguments. You've given us much to think about. We'll take the matter under advisement, issue a ruling in due course, and we are in recess.